take up our last case for today, which is Florida Bar versus Mirabal, number 2021-1469.
May it please the Court, Chief Justice, Justices, Counsel for the Florida Bar. My name is Herman Rosamano III, and I'm counsel for Miguel Mirabal, who's the respondent in this matter. The issue before the Court today is, even if the Court were to find that the Bar is proven by clear and convincing evidence that Mr. Mirabal's actions were knowingly, the appropriate sanction would be, under Standard 7.1b, imposing Lawrence sanctions, that a 1 to 3 year suspension, rehabilitation suspension, would be appropriate versus a disbarment. For purposes of background, the proceedings are, after the Florida Bar filed its complaint, knew all of the facts in support of its complaint, Florida Bar and other counsel for Mr. Mirabal consented to a 90-day suspension with probation. The referee, same Judge Casey, down in Fort Lauderdale, referee judge entered a 20-page opinion, facts and law, in support of that 90-day suspension. This Court rejected it, remanded it down. Back in December, there was 3 days of hearings on the matter. Final hearing occurs. The amended report, which is the operative report today, occurs. Recommendation of disbarment. So the standard for today and for the Court to address is this Court, despite the facts of the guilt factors, in reviewing its sanction, has the ultimate responsibility to enter the appropriate sanction, and the key is the existing case law. And that's the Bruce Jacobs case out of this Court recently in 2023. We know that plenty of cases are present in which disbarment is an extreme measure of discipline. Quote, and this is from the Sorayas case, 2004, never to be decreed where a punishment less severe would be accomplished by desired end. In the Summers case, the Court cites the language that's cited many, many times. Disbarment is rare, and where rehabilitation is highly improbable, it's the equivalent of the death penalty in a criminal case. It's our position that Mr. Mirabal can be rehabilitated. He can, with a 1 to 3 year suspension, which undoubtedly is severe suspension. Standard 7.1b for imposing lawyer sanctions provides suspension is appropriate when a lawyer knowingly engages in conduct that is a violation of a duty owed as a professional, causes injury, and is a potential injury to the client, the public, and the legal system. The facts of this case fall squarely within that standard. Injury has been alleged, and knowingly engaging in actions that Mr. Mirabal has admitted to.
Counsel, do you think it's appropriate to consider if his actions affected clients in a different way than if his actions affected the legal system as a whole?
I don't think you can make a distinction, because the case law, there's plenty of cases out of this Court where if you engage in this conduct as a judge or as a lawyer, as hurting a potential judge in this case, who became a judge in the 2018 election, or a client, or just the administration of justice, I don't think you can distinguish it. I think you have to base it upon the facts of this case, based on the existing case law, which I'll walk through with the Court, in that.
So can I clarify your argument, then it's not, excuse me, that we're precluded from imposing disbarment as a sanction, only that it's inappropriate based on the factual issue?
Of course. This Court's going to make its determination. My job is to advocate that it should be a 1 to 3 year suspension for this case, which is highly distinguishable from the cases the parties have been addressing. And now that we're on the topic, I just want to make a point. And this is interesting because we looked at everything. The referee judge cited the Orta case in reliance upon the disbarment. The Bar's brief I commend them for this. In their own answer brief, page 45, they do not dispute that the Orta case is distinguishable from these facts. Orta was serving a 3-year suspension after being convicted of tax evasion, and then he was hiding Canadian assets from the IRS, the probation, and the Florida Bar. Completely different here. And then in their answer brief, the Bar cites to 2 cases to support a disbarment from Mr. Mirabal, which are highly distinguishable and don't apply to these facts. The Kapoki case, 2021, Justice Curiel drafted that and wrote it. That defendant, or that respondent, served 20 days in jail for criminal contempt for lacking candor to the court because he was hiding a settlement agreement of money so his wife didn't get it in a divorce. He was disbarred by this court. And the Hall case is the second case that the bar relies upon in support of its position. Hall 2010. The court initially read the brief before oral argument and suspended the lawyer and said, we're going to have oral argument. After oral argument, this court disbarred Hall. He had 2 felonies for grand theft, for a fraudulent estate agreement, and here's what he did. And the court, remember, in 2010, Hall went to a family that had Alzheimer's and fraudulently created a document so that Hall can obtain their property.
Those cases just significantly different in kind from the facts here, where we have kind of the similarity in hiding the ball in a significant way in an important proceeding, and then you kind of compound that with this affirmative misrepresentation in the letter. I know the facts are different, but why is that so different in kind that they can't inform what this court should do in this case?
Because of the harm. The harm involved is completely distinguishable. So the court has to engage from a broad scope, look at what harm was done, what harm could have been done. And the fact that you're going to, here was one of the family members that has Alzheimer's, tricking them into a signed document, recording it in the record in order so the lawyer can get a property for their own interests. It wasn't for a client. It's highly distinguishable from what we're dealing with here. And Mr. Mabel's admitted that what his actions, and there's no doubt, he signed the certifications, the briefs are well done on both sides, that he knowingly did it. And that's why I focus on the 7.1b on the suspension. And I did this. My former co-counsel, who's now been elevated to the bench, Mr. Tynan and I, when we did our briefs, we looked for all the judicial campaign and propriety cases. And they're in all the papers. We cite to 8 cases. Every single one of the cases in which a judge or a potential judge, a lawyer at the time, was engaging in judicial campaign nonsense and no-nos shouldn't be done, they received a public reprimand from this court or up to a 90-day. I looked at all the cases. And specifically, early 2023, recent case, public reprimand, personally soliciting donations, and campaign finance report inaccuracies, similar to this case.
Well, I think that case is a little distinguishable. If I know the one you're talking about, there was not a repeated pattern of, inflating and then deflating reports and conveniently forgetting large judgments.
You're correct. You're 100% correct, and that's why this court said it's a public reprimand. And that's why I'm advocating that this court suspend Mr. Mirabal for 1 to 3 years. Significant punishment difference. So you're right. And that's why I make these distinctions. If this court found that a public reprimand or up to a 90-day was appropriate for now Judge Collindy, 2010, this court, campaign finance and proprieties, improperly filing financial disclosures. The Fracas-Santino case, 2021, the referee in this case cited to it. 90-day suspension. Misconduct, reckless disregard for the truth, and portraying the opponent as a criminal. In the Kinsey case, 2003, there's a public reprimand, 11 ethical violations by a potential judicial running for judge.
I think we could go all day sort of citing cases and where they are on the spectrum. I think maybe what I at least would like to hear is what your assessment is of your client's remorse for what happened. Because on the record before us, it would seem to me like that's a significant consideration in determining whether or not disbarment or some form of rehabilitation is appropriate.
Good question, and here's the answer. At transcript 3, pages 98 through 101, the record shows that Mr. Mirabal at the trial, final hearing, expressed his remorse for pages. He expressed his remorse for his actions. He admitted to it. So it's in the record. And not only that, and it's a mitigating factor. The mitigating factor, and I haven't said it yet, but you know it, it's in the briefs, he's never been disciplined by the bar for 20 years, admitted in 2004. So for 20 years, and let's say it's 18 to 17, because that's when in 2018 this issue started, he did the right thing up to a certain time and then did the wrong thing. but the wrong thing can be corrected with rehabilitation. It can't. A 3-year suspension by this court, which he must then, all know 3 years is more than 3 years. He's got to come back and show the bar that he's rehabilitated. It's another burden to establish. But his disbarment, on the facts of this case and the existing law, I respectfully submit it's inappropriate based on the facts of the case. And in addition to the mitigation.
Counsel, the referee didn't find remorse as a mitigating factor, correct?
That's correct. It's not in the report. However, in order to answer Justice Carroll's question, it's in the record. So the referee wrote what the referee wrote. We all have to accept it as it's written, but I wanted to at least address that. It wasn't like he's never been remorseful. It's in the transcript under oath, and he swore to it, and it shows remorse. And admittedly,
well, couldn't we infer that the referee discredited that?
You could. And
he
that's,
did not find it. I mean,
the referee did not find it, but there was remorse expressed on the record at the trial. So it was. In addition, other penalties and sanctions, which is a mitigating factor, 3.B11, Mr. Mirabal voluntarily resigned from the bench. He paid the fine. It's a nominal fine. That's not the issue. He paid the fine to the Florida Elections Commission. The referee found that was a mitigating factor. Character witnesses, there were 6 of them, referee found that was a mitigating factor. And in the end, we also cite in our papers, and this is interesting, the integrity of a judge. When one attacks another judge, you should never do it. Most lawyers, only a few are crazy enough to do it. But in terms of this particular fact pattern, there was a letter that was written to the bar that only the bar received. It wasn't disseminated. And why do I reference this? I go back to the Bruce Jacobs case, 2023. I practiced with Bruce in Miami. The things that Bruce wrote in papers, astonishing. This court has suspended him for 91 days. So I just want, for the existing case law, to be evaluated in terms of what the proper reprimand is. And another case, the Ray case, 2001, I know that's before 2015 when this court has set a precedent by saying we're going to put harsher sanctions. I get it. 3 letters attacking judges by Ray, and he was just public reprimand. So I want to be brief. My point is that the facts are what the facts are, even with the knowingly factor that Mr. Mirabal knowingly did what he did. This court, under the standard, 7.1b, and under the case law that I've cited in our papers and in oral argument, we respectfully request that this court suspend Mr. Mirabal for 1 to 3 years with a rehabilitation suspension and not give him the ultimate sanction of a disbarment. Thank you very much.
Thank you.
May it please the court, Mark Mason, I'm here on behalf of the Florida Bar. Joining me is Melissa Howland, my paralegal. We are requesting this court approve the referee's recommendation of Mr. Mirabal's disbarment from the practice of law. Now, by way of background, I know there was mention of the consent judgment, but what wasn't discussed was the full nature of the misconduct. And I think that's important because this court said in Orta that cumulative misconduct is dealt with much more harshly than isolated instances of misconduct. So what we have here is a theme. It's in the initial brief, it's in the reply brief, where we have conduct that spans 3 different time periods: the 2018 campaign, those reports, the 2019 JNC application, and then the letter to the bar. 3 different time periods where either we're having express misstatements being made while he's certifying to the truth of them, or he's committing these misrepresentations by omission. And it's repeated. In 2018, he's submitting these campaign reports that are inflating the amount of money he's actually raised, and he's certifying to them each and every month. There was extensive examination on that point, and every time it was, oh, this was an error, this was unintentional, I didn't mean to. These are the constant excuses that were given at the disciplinary hearing.
Counsel, do you think whether or not we determine what discipline is appropriate here, do you agree with opposing counsel that this case would be an outlier in comparison with our prior discipline for these types of issues?
No, I do not believe it's an outlier, and I say that for a few reasons. I know there's going to be factual distinctions in any case I cite. Certainly Orta, that point was already made that he was subject to prior suspensions, but that's why I also argued Kepke and Hall, also referenced. They had no prior discipline, and yet they were disbarred for their dishonesty, which was committed in a judicial proceeding. Now, is there a huge difference with the fact that this didn't occur inside a courtroom? I don't believe so.
Well, Kepke and Hall both involve convictions, right?
Correct.
Of a crime.
Yes.
There's no conviction here, right?
There's no conviction here. All we have is we do have the violation that he stipulated to in that consent order regarding the campaign finance violations. But in just viewing what he did, I think the bar's concern is not so much the label you put on it, but whether we have a pattern of dishonesty where disbarment is appropriate. So, no, we don't have a conviction. We have him stipulating that he violated to a statute regarding his monthly campaign reports, and that has knowing as an element of the offense. Yet he still argued at the disciplinary hearing throughout his initial brief that all of this was unintentional. So the question becomes...
Can I ask you the same question I asked the other side about remorse? Mm-hmm. Certainly, we can find record sites to support a statement about remorse, but we weren't present for the proceedings below. We don't, other than to just sort of reverse engineer what the referee found from the order, we can only conclude the referee did not credit those. Is there anything you want to add on that front? Because it would seem to me like that is an important consideration.
What I'll say about that is that I can't tell you I've ever read a sanction hearing where the respondent hasn't expressed remorse, because at that point there's been a finding of guilt. When a referee declines to make a finding regarding the presence of an aggravating or mitigating factor, it's entitled to the same deference you would give if the referee found that mitigating factor. So pointing to record evidence that says my client is remorseful, it doesn't prove that the referee was clearly erroneous in the ruling. It just indicates that the referee didn't accept that testimony by implication, by the fact that it's not in there. And I think that's readily apparent by the fact that you have this referee's report that goes through the litany of misconduct spanning these 3 different time periods, and then ultimately says, yes, I did originally agree to consent judgment, but that was rejected. I conducted a full hearing. I learned the breadth of what he did, and therefore I am changing my recommendation to disbarment. This wasn't some blindside type deal. It was throughout the hearing, you were hearing about these campaign reports, you were hearing about the JNC application where he was omitting 6 civil cases, number one.
It does sort of beg the question, though, about why the bar agreed to the consent judgment in the first place.
And the referee addressed that as well, at least from the referee's own perspective, that the original thought was, well, he stepped down from the bench, which was a significant other sanction, which would be a mitigating factor. That's why originally that was agreed to. But then when ultimately you start doing all of the fact-finding, you hear from Judge Abreu, who was the victim of these disparaging claims by Mr. Mirabal regarding her filing of a frivolous suit against someone, which never happened, and you combine that with the fact that he was also engaging in misconduct in 2018 and 2019 to try and become a judge when integrity was of paramount importance, not only in terms of his campaign, but in terms of the JNC application, when he's required to disclose, name every case where you've ever been a named party. And he omits 6 out of a total of 15, 2 of which, very frankly, and this is what the referee found, no one could reasonably forget. One of them was a lawsuit by the FDIC accusing him of engaging in mortgage fraud. And then the second one was his suit against Bank of America, which the referee characterized it as it resulted in a very scathing order by a federal judge, in which the federal judge said he drafted a deed in lieu and foreclosure. The bank never agreed to it, but he recorded it in the official records anyway, and then sued on the basis that they violated this agreement that no one ever agreed to except Mr. Mirabal. It's inconceivable that he would have just forgotten to disclose these things. And the referee found that this would necessarily mean that he was doing that because he didn't want to disclose something that would adversely affect his chances to fill a judicial vacancy. So when you look at the Orta case, it's not so much that it's relevant in terms of the specific facts, because Orta involved income tax evasion, and then the lawyer tried to get back into reinstatement and then just lied some more by failing to disclose certain holdings he had in Canada. And then that was uncovered, and then he does the same thing where he tries to excuse away what he did. The problem here is we are seeking disbarment because there's just been a constant pattern of dishonesty in these cases that so far has not been addressed. And yes, it's unusual for someone to suddenly get disbarred when they've had a clean disciplinary history, but it has happened before. It has happened in Kepke and Hall. And yes, you could say it's criminal conduct, it's different, but at the same time, when you combine what he did, all of the instances spanning 2018 and 2019, that distinction doesn't look quite as mitigating. So just in terms of the case law that I would...
Can I ask you a question on the finding on 4-8.2b, which is textually applicable to candidates for judicial office? Mm-hmm. That's imposed in the context of the bar discipline proceeding. Why is that not inapplicable in that situation when it's in the context of a bar discipline proceeding? It's a letter about a comment of who filed, the complaint, that sort of thing.
Yes, the Code of Judicial Conduct violation.
Yes.
He was running for office at that time. He actually succeeded in that, and that was 2020 when he was appointed to the position. So it became a bar violation.
But do you think, regardless of the timing, do you think it needs to be tied to activity in the context of the campaign versus in a disciplinary proceeding? Or is it just anything that a candidate does wrong in any proceeding is subject to discipline under that provision?
I think it applies when he is a candidate for office, and I don't think it necessarily needs to be tied to the specific race. But, I know there was a big deal made out of that specific rule violation in the reply brief, but we're talking about one instance, the last instance, out of several, and what he did in terms of falsely accusing a sitting judge, of filing a frivolous suit, which never happened. It violated several rules beside that one.
Right. So I guess two follow-ups based on that. One, are you aware of any cases that support kind of your interpretation that it's untethered to candidacy for judicial office as long as the person who's committing the violation is a candidate for judicial office? And then second, does that matter to our determination?
I don't have a case law for that. I would just go by what the Code of Judicial Conduct binds candidates to do in terms of that, and that's why the referee found that he violated the judicial canon through that as well. But in closing, I'm sorry, I don't mean to cut off if there are any other questions, but in closing, I would just ask this court to consider the case law, to consider the fact that, there is a litany of misconduct that, I didn't hear any argument here today, at least, that it was unintentional. There seems to be at least some kind of concession on that front, but at the same time, this has come a little late in the proceeding when the referee already failed to find that there was any remorse. And I think for that reason, there needs to be disbarment from the practice of law in this case. Thank you.
Thank you.
I'm going to be very brief, just to touch on a couple points in rebuttal. The consent of the 90-day suspension, in response to Justice Carrill's question, the bar, with all of its ammunition of bar history and case law, after it did its investigation, after it filed its complaint with this court, then entered into a 90-day. So they knowingly entered into that with the existing case law. This court had every right to remand it down.
We know that.
Right.
But that's ultimately, we decide what was appropriate, and that's why we rejected it and sent it back. So I don't really know that helps you.
I acknowledge that. In response to the comments about the three cases the bar is relying upon, Orta, Copel, and Hall, you're right. They're all conviction cases, serious conviction cases. Felonies for tax evasion, put in jail by a judge for hiding assets from a wife in a divorce. And in Hall, worst case scenario, you make an Alzheimer's homeowner sign a document and you have two felonies tacked onto that. highly distinguishable from the facts of this case. So I do think it matters that those are conviction cases which the bar is relying upon versus we don't have one here. In terms of mitigation, a huge factor is that Mr. Mirabal has no prior discipline. It's a huge factor. And there are several factors that the court found and did not find. And it's going to be up to this court to determine and weigh those factors. And finally, the lawyers imposing sanction standard 7.1b allows this court to enter a suspension when a respondent knowingly does something. Mr. Mirabal admits that he knowingly did these things, and therefore we respectfully request that this court impose a 1 to 3 year suspension because he can be rehabilitated. He can.
Well, counsel, let me say this. The rehabilitation issue comes into play primarily where we're determining that a disbarment will be permanent. And that's just like, go away, don't come back, ever. This is not a permanent disbarment, is it?
It's not. It's
Okay.
10 years. A disbarment of 10 years is a huge.
5.
Okay, I apologize.
It's 5 years. Again, there would be an opportunity to show rehabilitation after the 5 years and to come back. So this is not where, if we decide to uphold the referee's recommendation here, we're not saying that the petitioner here is beyond hope and is beyond redemption. That's not what's being said. It's just saying that you're out of the bar. And if you come back, it's going to be 5 years from now.
I don't disagree, but we all know there's a huge distinction between being disbarred and suspended, and the case law that we've cited supports a suspension and not a disbarment. Thank you for your time.